Good afternoon, our viewers at home. Hope you had a good Easter vacation. Today, we're back on Insights from Eximators Legal, and we'll be discussing another interesting concept under the law of the World Trade Organization. It has to do with trade and international trade within markets, international markets. My name is Esther, and I'm your host as usual. So today we'll be discussing anti-dumping under the WTO. What is dumping under international trade? What are the anti-dumping agreements under the World Trade Organization policies? What are the countermeasures the government can take to counter dumping in its jurisdiction? So we go straight to what is dumping. Dumping could mean different things in different economies, but most of the time, dumping is usually used when a product is unduly priced at a ridiculously low rate by an exporting company to export it out to a different jurisdiction. So I'll say it maybe in the academic parlance. It may mean exporting a product at an unduly low price to drive out competition in the importing country. So if a product, let's take for instance a particular line of clothing, I'll use that as an example. If a company in a country exports it to another country, another market, at a low price than what that type of cloth is being sold in that importing country, that means that exporting country had dumped those items in the importing country. So take for instance, let's say Germany, they make electronics for instance, and they come to Nigeria, import certain line of electronic products into the Nigerian market at a ridiculously low price to drive out the competition of that same type of product in Nigeria. Then that means they've dumped that item into the Nigerian market. Yes, of course you would say, yes, Nigerians will buy it. The price is a price market anyway. People will definitely buy because the price is low. But it's going to cause a material injury to the producers of the same line of products in the Nigerian market, because those products are being sold below their own cost of production in the same market. So that is actually what dumping means, literally. So we have something we call social dumping. Social dumping could mean exporting a product from a country where wages are extremely low into another economy, where the level of working conditions is far below that of an advanced country. And we've seen this happen in reality, where people export even labor, services, at a ridiculously lower price than what is obtainable in the advanced countries. So that's a form of dumping. So it's not only goods or products, services also could be dumped. So dumping could take different forms. It could take forms of sales below cost. So when items are being sold below the cost of production, maybe to drive out competition in that market, that's a form that dumping could take. So first, if competition is in the market, it may result in sales below cost, in the sense that a company could use dumping as a strategy. So in this case, we want to explain really that dumping could be materially advantageous for companies for them to be able to recoup a market. And it could also cause a material injury to another company, depending on the way it is done. So dumping has its merits and its demerits. It depends on how the government, the policies of those governments, of the states where those items are being traded. It depends on the way they handle the anti-dumping policies in their own jurisdictions. So a company could want to drive out competition in the market and sell its products at a lower price below the cost price. It could also secondly come in a way in which if there is a decline in demand in a market, maybe due to recession, the company could reduce its product price to be able to gain more traction in terms of sales. So that way, yes, it's a form of dumping, but it's to help profitability in that case of that company. Thirdly, a company could do something like a forward pricing in the sense that it sells its items below cost at the initial stage when the market is being introduced into the market, to eventually now increase its price later when people has maybe accepted its product in the market. So that's another form in which dumping could take in terms of sales below cost. So there's dumping also as international price discrimination. What do we mean by this? So we have a situation where, as a general term, when dumping is being used as an international price discrimination, it means the price of a product when sold in the importing country is less than the price of that particular product in the market of an exporting country. I'll take, for instance, we say an electronic item in Germany, for instance. If that particular item in Germany is being sold at a higher price in Germany, and that product is brought into Nigeria, that same product is sold at a lower price in the Nigerian market, being imported into the Nigerian market, then that is international price discrimination. And under the World Trade Organization, that is dumping in its material sense. So in the simplest of cases, one identifies dumping simply by comparing prices in the two markets, in the exporting market and in the importing market. So the situation actually is not that simple in most cases, because it's necessary to undertake a series of maybe price comparison. So what's the normal value of the sales of the product in the exporting country, and what's the normal value, or what's the fair value that the price is supposed to be sold in the importing country, of course, after considering what are the shipping costs and everything, landing costs in that sense. What's supposed to be the export price, compared to the normal price in the exporting country. Having said that, the World Trade Organization actually brings measures, to make sure that partner countries, member countries, don't have items, being dumped in their own jurisdiction at the detriment of locally produced items. We discussed in one of our series, the issue of the national treatment principle, where you have to treat the same item in the jurisdiction as the same way you treat an item that is imported in that same jurisdiction, and also the most favored nation clause. So these anti-dumping agreements and policies made by the World Trade Organization is actually in line with, auguring well with the most favored nation principles and the national treatment principles. So as we go on, we're going to, see this in greater detail. So what are the measures to counteract dumping? So to counteract dumping, countries impose anti-dumping duties on items, on imports. So if, say for instance, Nigerian government notices that a lot of products are being dumped into the Nigerian market, and they are being sold at extremely low prices, to the same line of products locally made in Nigeria, for instance, then it could impose anti-dumping duties to ensure that, to discourage the import of such items into the Nigerian market. So the anti-dumping duties are made on imports of the products that are being dumped. So an importing country may impose an anti-dumping duty on imported products if one, so we're going to state this line of ways in which measures can be made by government policies in their jurisdictions to counter dumping. One, if products are sold at a certain price in the domestic market of the exporting country, and such products or similar products are sold at a lower price in the market of the importing country. So definitely, anti-dumping duties will be imposed on such products. So if, like we give the example of Germany, if a particular electronic item, for instance, is being sold in Germany for a different price and is brought into the Nigerian market, sold at a lower price. In fact, so at times we find a situation where they are sold at a ridiculously low price just to come and be dumped on the Nigerian market. For those companies to be able to make their own gain off the Nigerian market while causing material injury, to the competitors in the Nigerian market, then the Nigerian government, now as a case study, will or could impose anti-dumping duties. In another situation where a domestic industry in the importing country is materially injured, yes, we know that, yes, part of these things about market economies, competition, there are healthy competitions, yet there could be very unhealthy competitions. If dumping is not curbed, it could result into serious unhealthy competition and cause material damage to the same line of products produced in the market in which those items are being dumped. So if the government of the importing country realizes that domestic industry is being materially injured by the items being dumped, then they will impose anti-dumping duties. Thirdly, if there's a causal relationship between dumping and the material injury. So in this sense, the maximum duty that may be imposed under the World Trade Organization rule is the difference between those two prices. So if there's a price, one item is being sold, and the dumped item is being sold at that lower price, then definitely the anti-dumping duties could impose the difference in the prices as a sum of tax or duty. When we say duty now, in terms of tax, maybe something to make sure that those companies are paying, for the items being dumped. So although World Trade Organization rules, normally, ideally, you condemn dumping, whether anti-dumping is a good policy, most of the time they say it's controversial, but we're not going into that today. We're going into how does the World Trade Organization view dumping and what are the measures they put in place to make sure that countries are not injured, trade between countries are not materially injured because of dumping activities. So we have regulations, under the World Trade Organization, under the GATT, the General Agreement on Tariffs and Trade. And it's quite interesting, and instructive to note here that the agreement on the implementation of the Article 6 of the General Agreement on Tariffs and Trade, that's the 1994, made in 1994, we call it the AD Agreement, that's the Anti-Dumping Agreement. It governs the application of anti-dumping measures by members of the World Trade Organizations. So anti-dumping measures are unilaterally remedies which may be applied by a member after an investigation has been made and there's a determination by that member country. When we say member now, we've discussed in previous series about member countries of the World Trade Organization. So a member of the World Trade Organization, there are different countries, there are members of the World Trade Organization, who trade between each other. So if there's a determination, after investigation has been made, in accordance with the provisions of the anti-dumping agreement, that an imported product is being dumped in the territory of one of the member states, and that dumped import items are causing material injury to a domestic industry producing similar products, then definitely the anti-dumping agreement will set in. So, under the WTO, when we say WTO now, we're talking about the World Trade Organization, we need to establish this fact that if a company exports a product at a price lower than the price it normally charges in its own country or in its own market, yes, it is called dumping of that product. The World Trade Organization agreement normally does not regulate the actions of companies that engage in dumping. What the World Trade Organization focuses on is how governments, because don't forget, World Trade Organization deals with governments, deals with polities, nations, member nations. They don't deal with individual companies. So what the World Trade Organization will focus on is how does the government of those imported markets, how can they or can they not react to dumping? So it's the anti-dumping agreement disciplines anti-dumping actions. And these anti-dumping actions are what we call the anti-dumping agreements. So moving forward, as we have explained earlier, the anti-dumping agreement sets forth certain substantive requirements that must be fulfilled in order to impose an anti-dumping measure, as well as detailed procedural requirements. So we have anti-dumping agreements setting out substantive measures and procedural measures, to be able to curb anti-dumping duties in member states. So where there have been conduct of anti-dumping based on investigations and imposition of maintenance in place of anti-dumping measures. So a failure to respect either the substantive or procedural requirements can be taken to dispute settlement. So if countries now, member states, in their own jurisdictions, they've made policies, substantive policies, procedural policies to curb dumping. They've made anti-dumping measures. So if there's been a violation of such, maybe by a member state's company, member states will not do business. It's their citizens, it's the companies, the juristic personalities in their own states that will come and do business with another country who is also a member state of the WTO. So most of the time, when they go into dispute settlement, when they take matters to arbitration, for the WTO to determine, it's going to be an issue of, okay, that host state or that home state where the market is versus the company in another member state, that are involved in the dumping. So a failure to respect the substantive or the procedural requirements will definitely take the matter to dispute settlement. And this may be the basis for the invalidation of the anti-dumping measure or the validation of same. Article 6 of the General Agreement on Trade and Tariffs, as we have mentioned, in 1994, yes, authorizes the imposition of a specific anti-dumping duty on imports from a particular source in excess of bound rates. So in cases where dumping causes or threatens injury to a domestic or materially retards the establishment of a domestic industry. So if the dumping of those items will definitely cause a material damage to the business of a domestic company in that host state where the items are being imported into, then definitely the government of those nations will frown at it and they will definitely penalize based on anti-dumping agreements under the WTO. So the anti-dumping agreement provides further elaboration on the basic principles set forth in Article 6 itself. We mentioned the issue of the Article 6 when we were talking about the most favored nation principle. So the anti-dumping agreement, we need to establish, it governs the investigation, determination, and application of anti-dumping duties in the host state and between polities, where those items are being dumped. Having said all this, it is very important and instructive to state here before we round up, on this discourse today, that yes, countries are allowed, juristic personalities, companies in different nations are allowed to do business. That's what the World Trade Organization is for, to facilitate international trade among member states. However, it should not be to the detriment of domestic items in those imported countries. It is very, very important. And countries have rights under the World Trade Organization to frown at any dumping measure that affects, whether materially or even in any small way, that affects and causes a material damage to countries producing similar items in its own jurisdiction. So that is what the governments are for, to protect companies, businesses in their own jurisdictions. So yes, imports are allowed. Companies from another country can export into another country, but not to the disadvantage of companies producing similar items in those member states. So today, we've been able to establish what dumping means, what are the anti-dumping measures under the World Trade Organization's policies. We've been able to also, explain to us that there could be advantages to dumping. There could be reasons why a company could result into dumping for a particular period of time. Maybe yes, to be able to introduce its item into the market so that people can embrace that product. If it's a new product, they could definitely produce and sell at a ridiculously lower price to ensure that yes, people accept their product in the market. But after a while, after they've gained the market traction, it is business sense to price the items in the normal way, not in another ridiculously low price that will now drive out competition ridiculously. So this is very important to note. And when it comes to international price discrimination, we've been able to establish also that where the price of a product, when sold in the importing country, is less than the price of that product in the market of the exporting country, that is definitely dumping internationally, and it will be frowned at by the countries in question. So thank you very much. Today we've been able to establish, what dumping is, what are the anti-dumping agreements, imposed by the World Trade Organization. So definitely, up next week, we'll bring you another interesting episode to talk about another area of international commercial law, which is also interesting from insights from Eximet as we go. Thank you very much and have a lovely weekend.